Since 1986, when the summary judgment trilogy came down, going to Daubert and Iqbal and Dukes, there's been a whole series of cases that have been decided under the guise of making our judicial system more efficient. And these cases really are not about efficiency. These cases are about basically discouraging plaintiffs from bringing cases, making it more difficult for plaintiffs to bring cases. And at the end of the day, what's really happening is that the compliance enforcement system in our country that has for many years been so heavily reliant on civil litigation is being damaged. Since the post-Civil War statutes in 1981, 1983. Our nation has relied on private citizens to help enforce the laws. And we see that in the antitrust laws. We see that in Title VII of the 1964 Civil Rights Act. We see that in fraud on the market litigation. We see that under the Federal False Claims Act. And we see that under a whole host of environmental laws that were passed in the 1970s. And when you make it more difficult for private citizens to enforce compliance, basically what happens is you're taking away a large portion of our compliance enforcement mechanism. And for those who do this, they would say it's about freedom, that companies should be free from regulation. But I'm reminded of the words of the Nobel laureate Mr. Stiglitz, who said that freedom is the right of one man not to be injured by another man's wrongful conduct. And I look at freedom from that perspective.